SJC-13022, Commonwealth versus Andrew MacCormack.
Okay, Attorney Maidman, whenever you're ready.
Good morning, and may it please the court. Stephen Maidman for Andrew MacCormack, the defendant in this case. What I'd like to do is start by addressing the constitutional issue of whether there was sufficient evidence to convict the defendant of the crime, and then turn to whether the admission of the Backpage.com evidence was an abuse of discretion by the judge and overwhelmingly prejudicial. The defendant argues that the evidence was insufficient to convict him of the crime, whether viewed individually, individual elements of the evidence, or collectively. What the Commonwealth proved was they largely attacked the defendant's character, and the evidence was not pretty in this case. They proved beyond a reasonable doubt that the defendant was a drug addict.
Let's get to the sort of harder parts, okay? So there's an enormous cleanup after this, right?
Yes.
By the way, is there testimony the door's locked? When the defendant comes back to the house, is there testimony that he unlocks the doors?
That would have been in his statement to the police, and I think it was equivocal. It was equivocal.
Is that,
Not clear.
I haven't read the whole transcript, but they do, it's really well argued. I mean, the closings are both, the judge compliments the closing, but the Commonwealth's closing, you've got it looks like a locked house. You've got somebody who's cleaned up for an enormous amount of time on a Saturday morning. It just doesn't seem like anyone else could possibly do all of these things. You want to address those? I understand you don't like all the character evidence. It's bad, but it provides motive and other things. But I just want to deal with the sort of who could have done this but him evidence.
Well,
the doors seem to be locked. You have to clean up for 4 hours knowing you're not going to get interrupted. You need to really know the house really well to do all of this. There's not nothing is left behind. The bleach, just deal with that part rather than the character, because I'd like to understand how anyone else could do this.
sure. That was the Commonwealth's argument. And look at those, just taking what you just said, those elements individually. If viewed from through the prism of the presumption of innocence, that does not prove he did it. I know the Commonwealth argued, though, who else could have done it? Matter of fact, they claimed that the absence of evidence proved he did, that he did it. But taking a look at that, that does not amount to sufficient evidence of guilt. Sure, but we don't know whether third parties were involved.
But if the doors are locked, the doors are locked when you come home, if there's this enormous cleanup that takes hours and hours, there's a huge amount of circumstantial evidence here that indicates he's the only one who could have done this, isn't there?
Well, that's the argument. There's no question that's the argument. But on the other hand, I would also point out the jury was out for 5 days on this.
Right.
Okay? 5 full days, parts of 2 other days. And so it was not, there's some kind of a disconnect when the defendant's arguing, and same argument at trial. The arguments on appeal and on trial are pretty similar. Okay? There's some kind of a disconnect when my sister will argue the evidence is overwhelming, and I'm arguing that it was insufficient. And apparently the jury thought, at least the jury, whether they got it right or wrong is a different issue, but nonetheless,
it's a first-degree murder conviction. Maybe they were struggling with first-degree versus second-degree, right?
Could have been. Obviously, I don't know the answer to that question, and no one will ever know, since there was obviously no inquiry of the jury, and that would have been beyond the scope of an inquiry of a jury. But that was the Commonwealth's argument, and his argument is that looking at all those pieces individually, Commonwealth has an obligation to make it add up. And you know, if you look at, again, I emphasize this, there's only one Supreme Court case I could find explaining the presumption of innocence. It's in every jury instruction that's given in the Commonwealth. But there's only one case, and what it basically says is that it's got to be based on the evidence adduced at trial, not based on the suspicions that result from him being charged with the crime.
Mr. Maven, these opportunity, inculpatory statement type cases that we've seen, purely circumstantial cases, what's the best case, closest case to this that helps you or should guide us?
I don't know the answer to that. I don't think there's any particular case. This case is so fact-specific. The Commonwealth cited...
they're all fact-specific, but there's a typical, who else could have done it?
Right.
This is the opportunity, this is the time factor, and these were the statements that don't jive with the evidence. I was just wondering, and I read the briefs, but is there a particular case that that is purely circumstantial, that goes one way or the other way?
No, just God's, there is one case I saw in the Commonwealth brief where they talk about motive opportunity, all of that. But I think it's Coombs. I'm not sure. It's in their brief. But nonetheless, these are unique circumstances. If you look at all the other evidence, that the cell phones, okay, the DNA evidence, none of that pointed to him. There is no forensic evidence against him in this entire case. Okay? The blood, the Commonwealth had some blood evidence. Turned out it was his blood in the car. It wasn't hers. The same thing with this.
I get your argument, because it's basically who else but the husband in these types of cases.
Yeah,
but maybe that's true. I don't know.
Again, even the cell phone evidence. Commonwealth had this theory that he took her phone. And so they did a massive evidentiary presentation on cell phones. Well, that helped the defendant. If anything, that may have proved that he didn't take the phone. I mean, there's many examples.
Didn't work on the jury, though.
Well, it may have worked on the jury. We don't know that. He got convicted, obviously, but...
and one thing I missed, and I should have... Did he smell of bleach?
No. Every witness said he didn't smell of bleach. And this defendant... there's evidence in the record that he was kind of scatterbrained, that he had erratic behavior, that he, it would have required, and this was argued at trial, it would have required this guy to be a genius to have pulled this off with no forensic evidence available to the Commonwealth.
Well, he lives in the house, right?
Yes, even the DNA evidence. I mean, of course, the DNA evidence had been all over the house.
So
and he lives there.
He lived there. That's exactly right.
But, I mean, the damaging part, obviously, is he gives this long statement about what he did, which is not corroborated. It actually turns out to be misleading.
Yes, that's right. But even that, you have to, even all that statement, and I guess I want to make sure I save some time to talk about the back page evidence. Even that, he never admitted he committed the crime. This guy, if anything, had every reason to stay married. No history of domestic violence, no nothing. In fact, one thing,
Counsel, may I go back on that?
Yes.
You're right, but when you look at the evidence that she clearly didn't want to stay married, so wouldn't that militate in favor of the motivation for this?
No, I'm not sure that's the evidence, Judge.
Well, but don't you think, Counsel?
Well, there were text messages, weren't there?
But yes, she did threaten to divorce him and stuff like that. But they go both ways.
Can I ask you one question about the bleach, though? Wasn't there evidence that he had some kind of a rash?
Yes.
Wasn't that somehow tied to?
They tried.
Okay.
They tried. Then his mother took pictures the night before. Apparently he had some kind of an itch, okay, and he couldn't see on his back, so his mother took pictures. Time-stamped pictures, done with an iPhone.
Yeah, but
night before, showing the rash.
That's kind of interesting, the rash, though, right? So, okay, so there is evidence that the house stunk from bleach, right?
Yes.
Stunk from it.
Yes.
The cops notice it. Your client doesn't mention it or notice it. But then and we're going to ask the Commonwealth about the bleach and the rash testimony, but the mother doesn't bring up the phone rash stuff at grand jury, right? She somehow remembers it, and it's a very odd thing. You'd think this would have come up earlier at grand jury, right? That
Well, you know, I thought
she's taken pictures with his phone. And by the way, do we have the rash? It's like picture day today, but is the rash picture, because I understand it's indistinct, is it in our record?
Yes. I don't have a, that wouldn't reproduce. And there was a big debate about what the picture showed as well. But yes, the pictures were introduced with their time, you know, the timestamps and all that.
Right.
But, you know, the whole rash argument, I'm not sure what the jury did with that. And as far as the grand jury, I know exactly what you're referring to in terms, because that came, I mean, the Commonwealth made a big deal about that, saying, well, she didn't testify at the grand jury about this, and how come you didn't testify? I mean, I've never testified in front of a grand jury, but if they don't ask me about it, I'm not telling them, and more than that, I may not remember it.
Well, but it's exonerating your son. You wouldn't remember that.
Well, assuming that was an issue, but you got to remember, this was very early on in the case. Who knew whether that was even an issue? I can't address that other than what the record says. Did you have another question for me?
No, I didn't, thank you.
On the back page information,
Yes.
we have to look at that for abuse of discretion, and he says we had a great marriage. That opens the door to, we didn't have a great marriage, right?
Well, it was actually, the judge's explanation was a little more than that. Okay.
I hope so.
Oh, it was. First of all, the jury was never vetted on back-page evidence, because that would have been ineffective assistance of counsel, because it was not clear that evidence was coming in until almost the end of the trial.
I'm sorry, I didn't get you. The jury wasn't vetted?
There were no jury questions. When they did the veneer, there were no questions about backpage.com. And that was probably the right decision at the time, at least from an ineffective assistance of counsel standpoint. He did not know it was coming in. And for a good part of the case, it wasn't coming in.
Well, he knew there was discovery, I assume. He knew.
I'm sorry, I didn't
He
hear.
knew it was out there.
Oh, sure he did.
Yeah.
Sure he did. But if it wasn't coming in and for the jury to be questioned on it, that would have been,
It wasn't a motion in limine?
oh, yes, there were plenty of, this was the most litigated issue in the case,
Okay.
okay?
And what did the judge rule?
The judge, at first she said it's not coming in. And there were some other nasty pictures there too that didn't come in. But one in
It
particular.
excludes the genital pictures that he sent.
Yes, that did not come in. That did not come in. She
Counsel,
wasn't
while
letting.
we're on the subject of the pictures, can you give me a record reference for the rash photo in the evidence? Because I can't find it in the appendix.
I think it's in my brief.
Okay.
I think it should be there, but there's no question it's in the record.
Okay.
If not, in the transcript for those pages. Her explanation was kind of interesting. Her explanation was repeated, and she used the word repeated remonstration about how happy his marriage was. If you go take a look at the tape recording from the state police, I'm sorry, the videotape of it, he says it once. And the defense counsel was very careful not to open that door. So if you look at it, the defense counsel always asked, any history of violence. It was not how great the marriage was. Okay, this was pretty strategic. Okay, and that's why. And then all of a sudden, she made the decision that, based on the totality, that again, but focusing on his claims of no infidelities and happy marriage. By the way, real question about what is an infidelity, and that came.
I don't want to get into.
Okay,
a few,
that was an issue.
I
in
didn't
the
want to
case.
get to a few presidents ago. It is an infidelity, but go on.
So
Doesn't it also show sort of his state of mind? He's behaving, he's a little out of control, right? His
he was a drug addict.
His drugs are kicking in. He's contacting a prostitute the night before the murder repeatedly, right? He's engaged in this endless search through Backpage.
He was
for like 4 hours or something. I can't remember. It's a lengthy back and
3
forth.
hours, 3 or 4 hours.
There was a meeting beforehand. Then the
Well, there was never a meeting. Okay, that never happened. They never were able to prove that. More than that, there's no evidence that it did happen.
Right,
Okay,
there was-
the evidence is did he make a date? And I was careful how I worded it, and the Commonwealth was very careful how they worded it. Okay, they never said he made a date. Okay,
plans to
Yeah, whatever.
And it was, we get the text messages, right? I
Right,
get it.
right. But you
Never
know,
produced evidence that it was consummated.
but let me address Justice Kafka on that. One of the questions is, they claim this showed he checked out of the marriage, okay? The marriage is over for him. That's inconsistent with other aspects of it.
I don't buy into that. I buy into the fact that he's out of control. You know, his drugs are kicking in. He's behaving in an irresponsible way in his marriage. He's doing a lot of things. It just seems this is relevant to,
Right.
if it's the night before, and it's also late into the night, right? It's like till 5 in the morning.
Yeah, can I just follow up on Justice Kafka's point? Could you just crystallize for me, how is that an abuse of discretion to let that evidence in to that relevant point? I just instead of just kind of saying the words, right? Because that's what we do. We just repeat what the standard is. Animate it for me. Tell me.
This was overwhelmingly prejudicial. This was and this word is not in the record, but there are law review articles on it. This was a sex trafficking website. Okay, this, if nothing else, this is what this body of law is designed to keep out. If the jury heard this stuff,
Well, but can't they admit evidence regarding the nature of the relationship or the state of the relationship? And wouldn't all of this go to the relationship between the victim and the defendant?
And could you remind us, was there a limiting instruction given by the judge once this evidence came in?
yes, there was the typical limiting instruction that you're familiar with, saying this went to, and there was some debate about it, but went to motive and intent.
And was that repeated at the close of the evidence, the limiting instruction? On how they could-
I don't remember, but I'm sure it was. This was the big issue.
Okay.
Okay, and certainly she gave it twice before the evidence came in, and this was highly discussed. But this, you think about it. This was exactly the type of evidence that this body of law is designed to keep. This made him sound like a sleazy husband who was just the type of guy who would have murdered his wife.
It's got to be prejudicial. That's why they wanted it.
Well, absolutely, the government.
The question is whether it's outweighed.
This was over the top.
Unfairly?
Quite frankly, I was shocked when I read this, like, as the first time. But this was absolutely, I cannot understand. I think there's the LL case which talked about no rational judge. I don't remember where I cited that, but bottom line is that
We've moved
I can't believe a judge would let this in.
We've moved beyond that test, right?
No, that's the new test. The LL is the newer one.
L is the right case?
Yeah.
Okay.
But then wouldn't that be, wouldn't the prejudice then be on the Commonwealth? Because if you have the opportunity to, I know you said it's not as numerous as maybe the trial judge made it seem, but we do have this statement or this evidence that he claims that we have this great marriage. So without allowing the Commonwealth to rebut that, isn't that unfair to the Commonwealth that the jury would be left with this false picture of domestic bliss that perhaps wasn't there?
The Commonwealth introduced an inordinate amount of evidence of just how bad this marriage was. Okay, there was no doubt. The jurors could not have been confused that this was not two lovebirds. Okay, it's very clear just reading the text messages. Okay, there were problems.
Right.
And what's interesting, let me just make one other point.
He's selling the wedding rings, you know.
Well, no, he didn't sell the wedding rings. That they want you to infer he
That's probably
sold.
not a good sign. Yeah.
The wedding rings disappeared. However, they disappeared. Commonwealth obviously, and they're very careful never to say he sold the wedding rings, because Commonwealth had access to all sorts of evidence about pawn shops.
I thought he pawned his own ring.
He did.
Okay.
And some other stuff.
Yeah, okay, so you're pawning your own wedding ring. That's also not a good sign.
Well, it depends if you want the money for your drugs.
So, counsel, can I go back to the question I asked you a few minutes ago? Is the abuse of discretion in that the back page evidence was cumulative of other evidence?
It certainly was cumulative that the marriage was not blissful. Overwhelming evidence of that, going back at least 9 months, or whatever number of months.
Did the Commonwealth even mention it in closing? I read the closing, but I can't remember. Did they bring up the back page in closing?
Yeah. They were careful how they did it. I think they realized that there was enough gasoline on the fire.
And I just should say that Judge Lowy would be disappointed if someone didn't mention Commonwealth versus Creighton as a proper legal standard. Commonwealth versus Creighton.
Oh, okay, okay. But, you know, the other thing, let me make one point. What the Commonwealth did is they went back at least 9 months, if we go back to forged checks, okay? And they used everything he did or that he didn't do as evidence that was sinister. And what the Commonwealth effectively did was, again, undermine the presumption of innocence. They went back so far, coming back, you know, he went and ran off when he was supposed to get a birthday cake. That's another example.
That may have been something that shouldn't have been in, but the night before the murder, the fact that he's really, you know,
Looking at a sleazy website.
well, more than that, he's arranging for a meeting with the escort. He doesn't get to do it. He's broke and in trouble and is spending $100, his last $100. You know,
I believe I cited some research, okay, that just because you go to a prostitute doesn't mean you murder your wife.
I totally understand that research, but we're trying to get a picture of this individual the night before the murder.
Right.
And it just seems like, you know, as Justice Stewart says, can we really say it's an abuse of discretion? You know, as Justice Gaziano said, it's clearly prejudicial, but it's also relevant in understanding the state of mind of someone who may have killed her. You know.
Well, that's the Commonwealth's argument. But again, I would argue that it was so overwhelmingly prejudicial that it denied him a fair trial. And unless the court has any further questions, I rely on my brief.
Thank you.
Thank you. Okay, Attorney Lewis.
Good morning, Your Honor. Sarah Lewis on behalf of the Commonwealth. With me today is the trial prosecutor in this case, Assistant District Attorney Ian Pollenbaum. I would also like to acknowledge the victim's parents who are in the courtroom with us today, and family and friends of the victim who are watching over the court's live stream. We are asking this court to affirm the defendant's conviction for the murder of his wife, Vanessa Masucci.
So, Ms. Lewis, same question. What's your best case as far as circumstantial evidence goes in this type of motive and opportunity?
I would cite Lodge. It's cited in the Commonwealth's, in the Commonwealth's brief, and also Robertson for the same proposition that motive, together with means and opportunity, and circumstantial evidence, consciousness of guilt in the aftermath, can all add up to provide circumstantial evidence that a defendant is culpable for the crime. That's exactly what we have in this case. But in addition, I would cite 4 categories of evidence: the motive here, the means, and the opportunity. I would also add that the manner in which the victim was killed shows an intimate familiarity between the perpetrator and the victim. And I think that's really important in this case, and the 4th category being the consciousness of guilt. But Justice Gaziano seemed to have...
on the manner, can you explain that to me?
Yes. The blood spatter evidence in this case showed that the murder occurred behind the closed bedroom door of this couple's home. That in and of itself shows this familiarity. Who else would be able to get into the bedroom in that manner, close the bedroom door? No evidence of a struggle that ensued. In fact, this physically fit woman did not harm the defendant. There was no evidence that he had scratches or any kind of injuries on him, therefore leading to a reasonable inference that she was surprised by this attack. In fact, the evidence suggests that he used perhaps the bed rail from the bed to hit her in the back of the head. She was found face down, blood spatter throughout the bedroom, and it looked like a surprise attack, again, without a struggle and behind this closed bedroom door. So that is, I think, important evidence in this case. And then you add that to the means and the opportunity. The fact that the CSLI evidence in this case, together with video surveillance, shows that he and the victim are alone at their home for a 4-hour period. Not only that, his own statements. He says, I'm home starting at, he says that she was woken up in the basement at 9 a.m. Now, the video surveillance shows that he had left at 8:30 a.m. and then returned. His mother testifies that she leaves at 8:30 a.m. So again, this testimony places these 2 people along with their young daughter at the home alone for a 4-hour period, after which he leaves and then goes on this ride throughout the city that the video surveillance then tracks, and which his statements, he does not disclose all of that evidence in his statements to the police, exactly his whereabouts, which adds to the consciousness of guilt here. So I would say, Your Honors, there is ample evidence of guilt in this case.
Can we, is the testimony that the door is locked when he comes to the house?
He tells the police that the basement door is locked and that he used keys to get inside of it as he's on the phone with his mother-in-law, with his mother-in-law.
We don't know if the front door is locked.
We don't know about the front door. There's also testimony that the victim's blood is found on a storm door in one area of the house, a small amount of blood, but there's not testimony as to whether or not the front door is locked, but there is testimony that there was absolutely no evidence of a break-in of any sort. The doors and the locks were intact, and there is evidence of that based on the search warrant and the search that was done of the home.
Now, the bleach and the photograph. So the house stinks from bleach, but there is this photograph that appears on his phone, and there's no contesting that the date stamp is accurate, right? That the night, either the day, I guess the day before, there's a picture taken of his back and chest.
Correct.
Which does lend some support that he's downstairs because of a rash, right? I mean, I'm not saying it's great support, but it's some support, right?
It could, and conflicting inferences, as this court knows, are for the jury to resolve. The mother testifies for the defendant that she, for the defense, excuse me, that she took these photographs. But there's also, and of course it didn't come in, there's evidence that he was taking photographs of himself that the judge excluded of his genitals, that she did say was overly prejudicial. But there's evidence he's taking pictures down there. So there's a conflicting inference. But I think it's also important to point out what the officers observed the next.
What is I haven't looked at this picture yet. What is this picture going to show us?
I cannot speak to that. I have looked at them. I have not compared those pictures to what I have not in recent days compared those photographs to the photographs of what the officers took. Officer McDougal took the next day, or the day of, when he's photographed at the police station. But I know that the photographs that Officer or Sergeant McDougal takes are Exhibit 3, and then Exhibit 3 is broken into various numbers, and I can certainly file a letter with this court pointing to the exact numbers of the photographs taken by the officers and then compare those to the photographs or give you the exact site for the photographs taken by the mother.
Because essentially, the Commonwealth's case is that he's used a tremendous amount of bleach. He's covered all his tracks with the bleach, right? That
Correct.
He's all the DNA evidence is wiped out. The house is spick and span besides where the killing takes place. It's none. But he doesn't smell from bleach. How do we?
Excuse me, I didn't mean to interrupt you.
Yeah, no,
I think one problem with, and respectfully, with the defendant's argument is isolating out little pieces of evidence and saying they do not prove beyond a reasonable doubt that the defendant murdered his wife. I think it's similar to the bleach evidence. The defendant walks into the house on the phone with his mother-in-law, and despite every single person who goes into that house afterwards says that the house smells overwhelmingly of bleach, he never mentions that. So you have that fact.
He's not asked it either, is he?
No, he's not. Well, he's not.
Is he asked? Wow, why does this house smell from bleach? Is he asked that question by the cops?
So I was just talking about when he walks into the house, but during his interview, they actually never strategically ask about the bleach, seeing if he'll bring it up, and he never does. Now, there was a question at the scene, I believe by Officer Mpemba about the bleach, and he actually gives information. He says, if we had bleach in the house, it would be in the basement. None is found down there. This also goes to the mean, and I know I'm weaving together evidence here, but this also goes to the means and opportunity. He has access to that bleach. It's not found. He has access to the largest knife in the knife block. that is no longer there. He says it was last there that morning. And you add these pieces of evidence up, and as this court knows, look at a whole, and in the light, taken in, as a whole, and in the light most favorable to the Commonwealth, was ample evidence of his guilt.
You didn't finish the point about the call with the mother-in-law. I didn't read the closing argument, but did Attorney Pollenbaum direct the jury's attention to, he's on the phone, everybody says the place reeks of bleach, but yet when he's on the phone with his mother-in-law, when he walks in, he doesn't say anything about it?
He did urge the jury to draw an inference based on that. Also said he never says her name.
The big thing he relies on, right, is that when he's driving with somebody, Karen or whoever the sister is, he says they're asking about, or maybe it's his under, I can't remember.
You're correct. He says, they asked me about bleach. They didn't ask him about bleach. Now, again, an officer at the scene did, but
That's the most, he's bringing it up with this person he's driving with, even though he wasn't asked about bleach.
Exactly, and he says something to the effect of, how am I supposed to know my wife's cleaning schedule? Yet at the scene, he said something that he had cleaned up in the days before. So there was some inconsistencies, which again, that goes to the category of consciousness of guilt.
Can you go through the process by which the judge admits the back page evidence? It was litigated, did she defer on it and wanted to see what the evidence was? How did that come to be?
Yes. So there was cross motions in limine on the issue that were heavily argued and litigated in the days before prior to impanelment. The judge says she's not convinced. She wants to hear how the evidence comes in. I will say that once impanelment begins, there is mention of whether defense counsel actually raises the issue of whether the prospective jurors should be questioned about the back page evidence. The judge says, well, I haven't made my ruling yet. This is actually on volume 1, pages 5 to 6. The judge says, I'm still considering the issue, and counsel says that they did not want to the question asked of the jurors, or did not want the impanelment delayed to resolve the issue. So that was discussed, and in fact, the issue is brought up again about questioning the jurors on volume 13, page 7. So stepping back to the process, the motion in limines were argued, impanelment ensued. The topic was raised again. The Commonwealth brought a renewed motion to admit the evidence. Further argument is had, and not until 6 days into the trial testimony does the judge decide to admit the evidence. After 6 days of testimony, and particularly what she said tipped the scales for her was the defendant's statement, and I think that's really important here.
The happy marriage reference?
Happy marriage, no infidelity, no financial problems. I slept in the basement because of an allergy to detergent, not because he's perusing Backpage.com for just under 3 hours and making a date with an escort that notably he did not keep. And I would say that the jury could reasonably infer because of the confrontation that ended up ensuing. I think also the Backpage evidence.
I'm confused by that.
Yes.
That he didn't meet with the escort. When was he supposed to meet with the escort?
10 a.m. on the day of the murder, when his CSLI and the video surveillance and her CSLI all placed them at the home for that 4-hour period between around 8:45 and 12:45. I also think the Backpage, Justice Gaziano, does that answer your question about the trajectory? And I think this evidence is, well, let me step back. Not only is the evidence relevant, and we can go to that point, but this judge carefully considered it. Judge Ames, quote, said she was admitting it in a very, very, very circumscribed manner. And she did. She excluded the evidence of the photograph he took. She asked that only the back page, that word, show up on his phone extraction, and any explanation of the exact ads he's perusing be redacted. And not only redacted, they were originally redacted in black. She said, I want it redacted in white so as to reduce any prejudice. So it was very careful. There were 2 contemporaneous limiting instructions when this evidence came in, and there was an instruction in the final charge to the jury regarding this evidence. Not only that the jury could use it to go to motive and intent, but specifically to state of mind. And that's really what this evidence went to. And there was a a nexus, a close nexus between this evidence and the time of the murder, and it part and parcel with his state of mind in the hours before he killed his wife. If your honors have no further questions on the back page evidence, I will conclude by saying that the defendant should not be granted any relief under Section 33E. This is a case where the defendant, in a gruesome fit of rage, attacked and killed his wife behind their closed bedroom door, as I mentioned, and while their 1-year-old daughter was watching television in the room, in the living room. The evidence indicates that he overpowered his wife, repeatedly struck her, forcefully strangled her, and as she was dying or once she was dead, stabbed her. For the reasons